3 days. That's all it took after Governor Newsom signed California's Glock ban for the lawsuits to start flying. But this isn't just any lawsuit. We're talking about a coalition of the biggest Second Amendment organizations in the country joining forces to take down what they're calling flagrantly unconstitutional. The Firearms Policy Coalition, NRA, and Second Amendment Foundation just dropped a legal bombshell that could change everything. And the evidence they're presenting? It's absolutely devastating to California's case. If you watched my last video about California's 3 new gun laws, you know I predicted the lawsuits would come fast and hard. Well, I wasn't wrong. On October 13th, just 3 days after Newsom signed a B 1127 into law, the legal cavalry arrived in federal court. This isn't some small-time legal challenge. We're talking about Jaymes versus Bonta, a federal lawsuit that brings together the heaviest hitters in Second Amendment litigation. And after reading through this 28-page complaint, I can tell you, California is in serious trouble. Today, we're going to break down exactly what this lawsuit says, why the legal arguments are so powerful, and what it means for gun owners not just in California, but across the entire country. Because make no mistake, this case could set precedent that protects gun rights nationwide. By the end of this video, you'll understand why even the ATF admits these guns are popular for civilian use, and how California's own exemptions prove they know this law is bogus. Before we dive into the legal details, I need to be crystal clear. I am not an attorney. This is not legal advice. This video is for information and entertainment purposes only. Always consult with a qualified legal professional in your jurisdiction for any legal questions or concerns. If this breakdown helps you understand what's happening, hit that like button and subscribe. It helps more people find this information when they need it most. Let's start with who's behind this lawsuit, because the coalition here is unprecedented. You've got the Firearms Policy Coalition leading the charge, joined by the NRA, the Second Amendment Foundation, and 3 individual plaintiffs, including a gun store owner and a California resident who wants to buy these banned handguns. But here's what makes this case so powerful. They're not just challenging the law on philosophical grounds. They're using hard data and legal precedent that California can't argue with. The lawsuit, filed in federal court in San Diego, directly challenges California Penal Code Section 27595A, the part of AB 1127 that bans what they call semi-automatic machine gun convertible pistols. That's California's fancy way of saying Glocks and similar handguns with cruciform trigger bars. Now, here's where California's argument falls apart immediately. The lawsuit points out that these handguns are in common use. Indeed, they are among the most popular firearms in the nation. And under the Supreme Court's Heller decision, if a firearm is in common use, it's constitutionally protected. Period. The legal team representing the plaintiffs isn't messing around either. We're talking about Cooper and Kirk and Benbrook Law Group. These are the firms that have been winning major Second Amendment cases across the country. Now let's talk about the evidence that's going to destroy California's case in court. The lawsuit includes some absolutely damning statistics that prove just how popular these handguns really are. In 2021 alone, Glock manufactured 581,944 handguns in the United States. Of those, only 67,106 were exported. That means over 514,000 Glocks were sold right here in America in just 1 year. And that's just domestic production. It doesn't even count imports. Speaking of imports, the lawsuit reveals that in 2021, over 1.6 million handguns were imported from Austria, where many Glocks are manufactured. We're talking about hundreds of thousands of additional Glocks entering the US market every single year. But here's the kicker. Even the ATF, the federal agency that regulates firearms, has officially stated that Glocks are popular for civilian use. When your own government admits these guns are commonly used by law-abiding citizens, how can you possibly argue they're too dangerous to sell? The lawsuit also points out that according to industry data, 3 different Glock models made the top 25 list for new gun sales in 2024. We're talking about the 4th, 7th, and 22nd most popular new firearms sold in America. California is essentially trying to ban some of the most popular handguns in the country and claiming they're somehow uniquely dangerous. The evidence says otherwise. Here's where California's hypocrisy becomes crystal clear, and it's laid out in black and white in this lawsuit. The law includes the usual carve-outs for law enforcement, but it goes even deeper than that. According to the complaint, the law exempts private party-to-private party transactions conducted through a licensed firearms dealer, sales to law enforcement officers, transfers for specific purposes, and even transfers to any forensic laboratory or forensic laboratory employee. Think about that for a second. If these handguns are so dangerous that regular citizens can't buy them, why can lab technicians? Why can cops? Why can people buy them in private sales but not from dealers? The lawsuit makes this point brilliantly. The Constitution does not allow elitist politicians to decide which constitutionally protected guns the people may own. That's a direct quote from FPC President Brandon Combs, and it cuts right to the heart of the issue. But here's the most damaging part of California's position. They're trying to ban these handguns based on a feature that has nothing to do with how the gun actually functions. The cruciform trigger bar is just an internal component. It doesn't make the gun more deadly, more accurate, or more dangerous in any way. The lawsuit points out that semi-automatic handguns with cruciform trigger bars are not different from any other type of semi-automatic handgun in a constitutionally relevant way. California is literally banning guns based on the shape of an internal part that most people have never even seen. Now let's talk about the legal precedent that makes this case almost impossible for California to win. The lawsuit builds on an existing case called Rena v. Bonta, where a federal court already found that California's handgun roster restrictions are likely unconstitutional. In that case, the court specifically mentioned Glock models as examples of handguns that are in common use and therefore protected by the Second Amendment. So California already had a federal judge telling them they can't ban these guns, and they passed this law anyway. The Supreme Court's Heller decision is crystal clear. Handguns are the quintessential self-defense weapon and the most popular weapon chosen by Americans for self-defense in the home. The court held that a complete prohibition of their use is invalid, but California is trying to argue that somehow Glocks are different from other handguns in a way that matters constitutionally. The lawsuit destroys this argument by pointing out that the only difference is an internal component that doesn't affect the gun's function, safety, or lethality. Under the Supreme Court's Bruin decision, California would need to show a historical tradition of regulating firearms based on internal trigger mechanisms. Good luck with that. This kind of regulation didn't exist when the Second Amendment was written, and it doesn't exist in most states today. The lawsuit notes that Massachusetts is the only other state that bans Glock handguns. So California is asking a federal court to believe that 48 states are wrong about the safety and constitutionality of these firearms. Here's what makes this lawsuit so strategically brilliant. It's not just about stopping one bad law. It's about establishing precedent that will protect gun rights nationwide. The plaintiffs are asking the court to declare the law unconstitutional both facially and as applied. That means they want the entire law struck down, not just specific applications of it. If they win, it sends a message to every anti-gun politician in the country that this kind of arbitrary ban won't stand. The timing is also perfect. With the Supreme Court's recent Second Amendment decisions in Heller, McDonald, and Bruin, the legal landscape has shifted dramatically in favor of gun rights. Federal courts are striking down gun control laws left and right, and California keeps giving them more opportunities to do it. The lawsuit is also smart about venue. It's filed in the Southern District of California, where there's already favorable precedent from the Rena case. The plaintiffs know this court has already expressed skepticism about California's handgun restrictions, but perhaps most importantly, this case could establish that states can't ban entire categories of popular firearms based on arbitrary technical features. That would protect gun owners from similar laws in other states and prevent the kind of feature-based bans that have been spreading across the country. Look, California thought they were being clever with this law. They thought they could ban popular handguns by focusing on an obscure internal component that most people don't understand. But this lawsuit exposes their strategy for what it really is: an end run around the Constitution. The evidence is overwhelming. These are some of the most popular handguns in America. They're in common use for lawful purposes, and there's no historical tradition of banning firearms based on trigger bar shapes. California's law fails every test the Supreme Court has established for gun regulations. This isn't just about California anymore. This case could set the precedent that protects the right to buy popular firearms nationwide. And with the legal firepower behind this lawsuit, California is going to have a very hard time defending the indefensible. If you want to stay updated on this case and others like it, smash that like button and subscribe. And when you're done here, check out another video on the channel. We've got plenty more coverage of the fight for your constitutional rights. The Second Amendment is winning in the courts, and cases like this prove that the tide is turning. California's days of trampling on gun rights are numbered.